we're going to be talking about willful blindness, and when we first were put on this program, we were putting together materials that you were given, and the materials are, quite frankly, a little bit outdated now as a result of a Supreme Court decision that nobody anticipated. And we're going to spend a lot of time talking about that. There's a handout. If you did not get the handout, please be sure to pick up a copy of the handout because it gives you the link to the new Supreme Court case and gives you some excerpts from it. And we also have a PowerPoint that, of course, we can provide.
And I just wanted to say, I mean, this panel this morning is the good news, bad news panel. I mean, the good news is that the Supreme Court has finally told us what the willful blindness doctrine means. The bad news is they did it in a patent case without any input from the criminal defense bar, and so there's still a lot of loose edges, but the materials are, in fact, now outdated because they were all written before the Global Tech case came down in the last month. Now, there's still some things you can use out of them, but they certainly didn't anticipate the Supreme Court would rewrite willful blindness in a patent case.
And the good news is there's a lot of great things in that global case. Let me just reference one article that just came out. It's in the Criminal Law Reporter. It's written by Dane Ball. And it's a wonderful article on the Global Tech case on willful blindness, and Dane has been kind enough to get me permission from the Criminal Law Reporter to post it on my White Collar Crime blog. It's not up there right now, but it will be up there within the next 24 hours, depending upon airplane flights.
I also wanted to give a shout out to that article. I think a lot of the things that we'll talk about today, particularly with respect to jury instructions, are laid out very nicely in that article. So if you have a willful blindness case, you really should use that article as a resource for your jury instructions.
We're going to talk about three things today. And why three? Well, because I was schooled by Terry McCarthy. And Terry McCarthy told me, whenever you're doing a presentation, you always do things in threes. And if you have four, make them three. If you have two, make them three. And so we're going to talk about three things. The first thing that we're going to talk about is what exactly is willful blindness. So I'm the academic. I'll probably go through a good portion of that. Then how to avoid an instruction on willful blindness gets more into the practical. Tim's going to take over there. And then if you can't avoid it, what's the best possible instruction that you can use? So those are basically the three aspects of what we're going to talk about today. So what exactly is this willful blindness? It's been called many things: the ostrich, the deliberate avoidance, deliberate ignorance, and those are the different terms that you'll hear used. I should tell you that Judge Posner out of the Seventh Circuit is rather upset that it is being called the ostrich instruction. He actually made a point in Conrad Black's case to do a whole section about the ostrich instruction, and then he noted in the decision that this is really a misnomer. He said the first is whether an ostrich instruction should have been given. The reference, of course, is to the legend that ostriches, when frightened, bury their head in the sand. It is pure legend and a canard on a very distinguished bird, and he cites to the Zoological Society of San Diego. I'm glad he's visiting those sites. Which he quotes, "When an ostrich senses danger and it cannot run away, it flops to the ground and remains still with its head and neck flat on the ground in front of it. Because the head and neck are lightly colored, they blend in with the color of the soil. From a distance, it just looks like the ostrich has buried its head in the sand because only the body is visible." He then goes on to say, "It is too late, however, to correct this injustice to the ostrich."
One of the nice things about Global Tech, I think, though, is that it might give us a chance to maybe redeem the reputation of the ostrich, because I do think that, and we'll talk about it more later, the Global Tech case really changes the paradigm in a way that I think the term really ought to be active avoidance, and it's not in any of the earlier terms, but the action is really going to be important, as we'll talk about later.
which you might want to use the ostrich who is laying his head and not burying his head in the sand. The willful blindness chronology comes from the English law. It dates back quite a ways. 1882 is its first reference in United States law. In 1962, the American Law Institute incorporated the doctrine into our basic sort of structure of criminal law. It defined knowledge as knowledge of the existence of a particular fact. It includes when a person is aware of a high probability of the fact's existence unless he actually believes that it does not exist. One of the interesting things about the American Law Institute's 1962 reference is that Global Tech goes back to the American Law Institute reference and uses it to build up something that we think is very helpful for criminal defense in that respect. May 31st, 2011 is the Supreme Court Global Tech's opinion where they stated, every court of appeals with the exception of the District of Columbia has fully embraced willful blindness, applying the doctrine to a wide range of criminal statutes. What is the classic willful blindness? The classic willful blindness comes in the United States versus Jewell case. You've got the situation where the defendant is going across the border, he's carrying 110 pounds of marijuana, it's concealed in a secret compartment between the trunk and the rear seat of the car. The defendant is convicted, and on appeal, there was a willful blindness instruction, and he raises the issue of whether that willful blindness instruction was proper. Now, the evidence in that particular case was the defendant sold the automobile for $100 that he owned in order to have a good time. He then goes out and he rents a car for $100, and he and a friend drive off to Mexico. There's no explanation of what they were doing for 11 hours in Mexico. They meet up with a guy named Ray in a Tijuana bar who tries to sell them marijuana. They don't buy the marijuana. They refuse to buy the marijuana, but he offers them if they will take a car back across the border, they can get $100. So they do it. At least the defendant does it. The friend, he wanted no part of driving the vehicle. He said it didn't sound right to him. They deliver the car allegedly to an address on a registration with the keys in an ashtray is what they're told. Of course, the individual living at the address when approached says they sold the car a year ago and haven't seen it since. The interesting part about the case is the court in the Jewell case says that the instruction was wrong. The instruction should have been that the required knowledge is established if the accused is aware of a high probability of the existence of the fact in question unless he actually believes it does not exist, which basically goes back to the American Law Institute's model penal code. The conviction was affirmed. Basically, it was a harmless error, but there was a dissent. And I emphasize the dissent here because the dissent was joined by 3 others. It was a California case, Ninth Circuit, en banc, and the person who wrote the dissent was Kennedy. Now, Kennedy eventually gets elevated up to the United States Supreme Court, and it's going to be interesting to see that he is now on the dissent on the Global Tech case. But he's got some interesting language there that I think is also useful for criminal defense lawyers. The ostrich defense has come up a lot in white-collar cases, just some high-profile cases, the Conrad Black case, the Shelton case, Bernie Ebbert case, Jeff Skilling's case. All of these cases and many more have had situations where an ostrich-type defense, willful blindness, has become an issue. Why? Because they did not know what was going on in the company. They didn't realize it was going on in the company, and so the prosecution tries to bring up as a possible way that they should have known is that they should have been aware of it.
One quick point on this. I think the evolution from Jewel to the list that Ellen put up is a good example of why, as white-collar practitioners, we shouldn't just wall ourselves off into the white-collar world and think that the rest of the law doesn't affect us. A lot of the really bad willful blindness case law was made in drug cases, was made in what we would typically think of as street crime cases. And I think that to the extent that, white-collar practitioners can get interested in that earlier, my observation is if the first case that comes up is in a white-collar case, you have a better chance of making good law on it. We had some very good Brady law in the District of Columbia that came up in one of the Abramoff cases, and I think part of the reason that the law was so good was that some of the issues in the Brady context that are sometimes there in blue-collar cases were not there in this Abramoff-type case. And so I do think that willful blindness is a good example of how it evolved from largely a doctrine in drug cases to one that is much more prevalent in the white-collar context now.
And just to add to that, if you look at the RICO cases, the best RICO cases are civil cases that came out of 1964. And so white-collar crime should not be thought of just as white-collar crime, and nor should all of criminal defense. I think you find some of the most helpful things. Personally, one of the reasons I work in the white-collar areas, I think you can have a lot more impact on the rest of criminal law through white-collar cases and changing the law. The Supreme Court issued its opinion. It was an 8-1 decision. Justice Alito wrote the decision in Global Tech. Of course, the dissent, who other than Justice Kennedy. It was a civil patent case. It had nothing to do with criminal law, and I went back and I looked at all the briefs in the case, and you know something? There's not one criminal law-related brief in that entire pile, in all the amicus briefs. You've got Google filing amicus briefs and all these other people filing amicus briefs, and nobody was talking about criminal law. It's the Deep Fryer case is what I call it. And why is it the Deep Fryer case? Well, it seems that Sunbeam gets this company, a Hong Kong maker of home appliances, its wholly owned subsidiary is Global Tech, to make these fryers. And they failed to inform the patent attorney that the design was copied from SEB. The attorney didn't locate, therefore, SEB's patent. Sunbeam undercuts SEB in the market, and then this company goes ahead, it sells it to other places such as Montgomery Ward's, and of course both are selling in the United States under their trademark, so they're not using the trademark of the original one who had the patent, and it doesn't come to light until, of course, SEB realizes that they're being undercut. So it comes across as a civil suit, it gets tried, it's a 5-day jury trial on infringement. And the Supreme Court eventually grants certiorari on it, and the patent statute has no mention of the word intent. And that's really an important part here, because you think of all the criminal statutes that have the word intent in, which leads me to believe we should even have a higher standard than what we're going to present in Global Tech. And the court holds, we agree that deliberate indifference to a known risk that a patent exists is not the appropriate standard under this patent statute. The court goes ahead and affirms the case because they find sufficient evidence to support the knowledge under the doctrine of willful blindness. So you get basically what happened in the Jewel case. It's the equivalent in the civil of the harmless error type of a standard. There's more than sufficient evidence. So, okay, they got it wrong, the statute. They got it wrong on the instruction, but we're going to go ahead and find that it's okay because of the other evidence that's there. The willful blindness in criminal law comes up in the decision out of the clear blue. My own personal opinion of why this is happening is because the court right now is made up of Harvard and Yale justices. And Yale and Harvard are very into interdisciplinary work. So I would say that probably some of these justices come from a background where they think interdisciplinary-wise. They don't think just criminal or just civil. And so they start putting the pieces together from like an academic type of perspective. That's my own personal opinion. I can't prove that, though. While the Court of Appeals articulates the doctrine of willful blindness in slightly different ways, the court says all appear to agree on two basic principles. The defendant must subjectively believe that there is a high probability that a fact exists, and two, the defendant must take deliberate actions to avoid learning that fact. We're going to focus on the deliberate actions words, by the way.
One quick point there. I don't know where the Supreme Court got the idea that the courts of appeals agree on that second element. I mean, they've said it, so it's now the law of the land, but a lot of the lower court cases did not include any requirement of deliberate action, and so the Supreme Court, I think it's fair to say, and I don't know if Ellen agrees with me, but that the Supreme Court pretty much made that second element up out of whole cloth.
I would agree. And I think Justice Kennedy makes a good point in that respect about how there were no criminal practitioners here and nobody's briefed the criminal law from the criminal perspective. He's got some great language there too, though. We think these requirements give willful blindness an approximately limited scope that surpasses recklessness and negligence. This is dynamite language, just superb language. The court goes on. Under this formulation, a willfully blind defendant is one who takes deliberate actions to avoid confirming a high probability of wrongdoing and who can almost be said to have actually known the critical facts. Can you just see your jury instruction based upon this? To have actually known the critical facts. And they quote to Williams in criminal law, and one of the quotes is, "A court can properly find willful," spelt with one L, not two L's there, "blindness only where it can almost be said that the defendant actually knew." This is incredible language, in my opinion. Now, the court contrasts that standard with recklessness and negligence. By contrast, a reckless defendant is one who merely knows a substantial and unjustified risk of such wrongdoing, and a negligent defendant is one who should have known of a similar risk, but in fact did not. So you've got some great instruction language here to contrast it with the recklessness and with the negligence, and why it has to be a deliberate action. What was wrong with this case? In this particular case, they affirmed, as happens so often, even in the civil contest. The test applied by the Federal Circuit in this case departs from the proper willful blindness standard in two important respects. First, it permits a finding of knowledge when there is a known risk that induce acts of infringing. One of the key aspects of this case was the concept of inducement in patent infringement. But the second point, in demanding only deliberate indifference to that risk, the Federal Circuit's test does not require active efforts by an inducer to avoid knowing when the infringing nature of the activities. That is just incredible language for an instruction. Okay, Justice Kennedy dissents. Now, why did he dissent? Remember, they affirmed this decision. He's upset that and dissents, therefore. He's chagrined that the court is using a criminal law doctrine here in a civil case where it has received no briefing or argument from the criminal defense bar, which might have provided important counsel on this deliberate issue. Quite frankly, I'm glad the criminal bar was not. It would have been nice if the criminal defense bar had a chance, but if the prosecution had a chance, I'm not sure we would have gotten this great language there. I mean, this slipped by everybody. Having interpreted the statute to require a showing of knowledge, the court holds that willful blindness will suffice. Justice Kennedy says this is a mistaken step. Willful blindness is not knowledge, And judges should not broaden a legislative prescription by analogy. I mean, that is great language that I think you can use also, even if it is part of a dissent. Nobody has used a statutory language basis to try to, what he's developed in this case and what he developed in the Jewell case, to take that the step further and say that the language itself of the statute should have included it. If they really wanted willful blindness, they should have put it in the statute. They didn't put it in the statute. Why should we read the statute that way? Based upon some English law?
So I guess now that we've talked about kind of what the Supreme Court just did to the law, I think we ought to talk a little bit about where this problem comes from, why we're having an entire panel on it at a white-collar conference, and then maybe some things that can be done with this Supreme Court case, because I agree completely with Ellen. The law, or the law that the Supreme Court laid out in this Global Tech case is just dynamite, and it's not something that we'd ever been getting out of the courts of appeal. One of the items in the materials is a cert petition that I did along with some people at my law firm from a case that one of my partners, Andy Wise, tried, where the big hole in the government's case was really that the client who was accused of lying to the Nuclear Regulatory Commission, and he was a supervisor in this company, where he had supposedly not done enough to verify what was in the submission to the NRC, and there was really no evidence that he had actively said, don't tell me, I don't want to know. I mean, the government's theory was, like it is in a lot of these cases, which is, you know, maybe he didn't know, but he sure should have. That's really the sort of case where willful blindness has come up the most, and it's the case that even before Global Tech, the courts of appeals had said, this is the real danger. Now, the problem before Global Tech was that the Court of Appeals had done a lot of things to take any teeth out of this doctrine, and so it was a really dangerous doctrine that was not limited in any way, even though every Court of Appeals in the country said it's a really dangerous doctrine that should be limited, but they didn't do it. But the Geisen case was one, as I mentioned, that not only was Mr. Geisen found responsible on a willful blindness theory, or at least the jury was instructed on willful blindness, and the jurors said afterwards that that's really the basis that they convicted, but it was really a case with no evidence of active steps for him as a supervisor to say, you know, don't tell me about this, I don't want to know about it. Which, when you think about it, there would really be no reason that a supervisor is going to do something like that. And the government had real problems with the motive theory, but they had a ton of evidence of negligence in the case because the client had gotten up on the stand and basically said, I wish I'd done better supervising this and I wish I'd done better supervising that, but I had no idea that the statements in the submission were false. And so that's the sort of case where it was most dangerous. And it's also the sort of the case that I think, you know, one of the problems with that case is that the government tried it on an actual knowledge theory. But it turned out, once they finished their case, they didn't really have almost any evidence that he knew that these submissions were false. And so it was a fallback that arose at the last minute. And so I think one of the lessons from the Geisen case is that the government, at least before Global Tech, is going to throw these things at the last minute in the weakest cases. And so there's a lot of strategic decisions involved, but you need to think about whether or not willful blindness is going to be part of your case beforehand and think, do I want to actively take efforts to rebut a willful blindness instruction that the prosecutor may never bring? And so that's one, the Geisen case is one that I think presents a pretty good example of the sort of facts that you might see. The Bork case is another one. And I guess both of these cases are examples of where, you know, criminal liability in the white-collar context has been expanded to managers and supervisors almost through a vicarious liability theory quite often. And Bork was one where he was an investor in an oil investment in Azerbaijan, and one of the guys who had collected the investors together, as it turned out, this Kozeny guy had been paying bribes. And I know that John Klein was one of the lawyers, Casey Maxwell was one of the lawyers, so I don't want to butcher the facts of Bork too much, but the government's theory was basically that Bork, even if he didn't know at the time that he made this investment, that bribery had taken place, he should have done a bunch of due diligence and learned about the bribes, And so it was almost a theory that the due diligence wasn't good enough to figure out the bribes, and therefore he was willfully blind to the fact that these guys had been paying bribes. What's missing in both of these cases is the active efforts, but until Global Tech, you couldn't get a jury instruction that said active efforts. But I think, you know, in the Bork case in particular, the evidence of other investors' due diligence, which got in front of the jury so that the jury could compare what some investors had done to what Bork had done, there's no way that that can come in post-Global Tech, because its pure purpose was to show what Bork should have done. And I think Global Tech makes it very clear that a comparison of, you know, one investigation with another due diligence investigation is not going to be good enough to get even to the jury in a willful blindness case. Sorry, technical difficulties. I guess maybe now I should make an announcement that we forgot to make before. Mr. Morales' glasses are in his guest room, so we forgot to make that announcement, so we're going to make it now. All right, so you can skip that one too. All right, so now that we've got the background in what's going on in these cases, I think that you want to think about from the start of your case, how am I going to challenge a willful blindness theory, and how am I going to use the Global Tech case to do that? First of all, in fact development, I think that because the Supreme Court has really focused on the active efforts and the need to show that the defendant took active steps to avoid learning knowledge. That is, they essentially said, don't tell me I don't want to know. Or in the Global Tech case, I think that the active efforts are very interesting to look at. I mean, what Global Tech had done was they did, the two things the Supreme Court pointed to was that they copied an item that didn't have a patent mark on it. So they got a foreign item that wouldn't have a US patent mark on it, so that the exact copy would include everything but the patent mark. So that was one effort to be able to say they didn't know there was a patent, because if they had copied it and the patent number had been on there, it'd be pretty obvious that they did know that it was a patented project or a product. And the second thing that they did is when they hired a lawyer to do the due diligence on whether or not this item was patented, they didn't tell the lawyer that they had copied the friar. And so the other active step that they did was they withheld, they did a due diligence investigation, but they actively withheld information from the lawyers who did the due diligence investigation. And so those were the two active steps that they took in that case. I think if you are looking at a case where the big issue is going to be whether or not your client had some sort of guilty knowledge, so in a false statement, if they knew that statements were false. In an FCPA case where the claim is that your client was a manager who knew that one of his subordinates in a foreign country was paying bribes, you're going to want to look and develop facts to show that your client took no active steps to avoid learning of anything. That to the extent that he didn't know, that it wasn't because he did anything actively to avoid learning about whatever it is that he was supposed to be guilty of. The second thing you're going to want to think of, and I alluded to this before, is whether or not you want to file motions in limine to preclude the government from relying on a willful blindness theory before the trial starts. And the danger here is that there are going to be some cases where maybe the government has not really thought about putting on a willful blindness case. And so if you file a motion in limine, you may trigger the government to start thinking about that, and you may get a willful blindness instruction in a case where you wouldn't have gotten one otherwise. But I think that the cat is pretty much out of the bag now in most jurisdictions, and so the thinking is that unless it's a case where the government is just likely to miss it, you want to think long and hard about whether or not you want to knock a willful blindness theory out of the case from the get-go, because there just isn't any effort that your client took active efforts to avoid learning about something, so that the government's either going to have to prove he knew that the statements were false, or that he knew that a bribe was paid, or your client's going to get acquitted. They're not going to be able to go on this, he almost knew under the willful blindness theory. You're going to want to develop these same sort of facts in cross-examination. I think those three areas are things that probably would have been obvious. The jury instruction issue is the one that I think is the most important here, because I think that one effect of Global Tech was that every jury instruction every pattern jury instruction that I've seen has probably been overruled by Global Tech. And we can talk a little bit in a few minutes about some of the problems, but the main one is obviously that Global Tech, I think, requires a very strict instruction on active efforts made by your client to avoid learning knowledge. And then the stuff that Ellen was talking about before with respect to recklessness. The pattern instructions that I have seen almost always make a reference to the fact that negligence or foolishness is not enough. But they were they don't, I haven't seen any, and there may be some out there, but I looked at a lot of the circuit pattern instructions yesterday just to confirm this. I don't think any of the circuits would rule out recklessness as a theory because the recklessness instructions and the recklessness standard was so close in a lot of jurisdictions to willful blindness. And so you get these pattern jury instructions that would say that to show willful blindness, the government needs to show that the defendant subjectively had a high probability, knew there was a high probability that a certain fact existed and consciously avoided learning of that fact. So they won't have active efforts, and then they'll say negligence and foolishness is not enough. That's most of the pattern instructions. Now they're going to have to, those instructions are wrong, I think, under Global Tech, and they're going to have to be rewritten, and I think you can rewrite them in some pretty strict ways that are going to be very helpful in a lot of these cases. Those are the two elements that we've talked about in terms of active avoidance. And so what are some of the steps that you could take to actively avoid knowledge? It's not clear to me that the Jewell case, which is kind of the seminal federal case about deliberate ignorance or willful blindness, would even meet that. Because this was the case where the guys took the car across the border and didn't know what was in it. Now, it's possible that the government would have tried to beef up the facts in that case by showing active things that the clients did or that Jewell did to avoid learning that there was marijuana in the car. But on the basic facts where essentially I think the government's theory was, come on, he had to know that there was something in the car. It wouldn't be enough because the second element is not going to be met. And so that's really the element to focus on in these cases. So the two Global Tech elements, I guess those are the most important two things to get into the instructions. And so if you're trying a case and willful blindness comes up or active avoidance comes up, I think you've got to make sure that this is the pattern instruction to flag because it's no longer any good. The elements from Global Tech will be easy to get in because they're obviously what the Supreme Court has said is the consensus view of the law now. The language that Ellen flagged earlier about the active efforts should also be easy to get in because it's right out of a Supreme Court opinion and it's pretty good. This is the part that may not have jumped out of you, but I think that these last two bullets are also very important. The negligence standard, a lot of these instructions will say willful blindness is not negligence. But what they won't then go on to do is define what negligence is. And so the Supreme Court decision in Global Tech defines what negligence is, and I think that's got to be in your instruction too, because I think what you want is a clear message to jurors that if all the government proved was that the defendant should have known, that's not enough. And the language that the Supreme Court uses in Global Tech is should have known. And so they equate negligence with should have known. I think you want that in your instruction when you're telling jurors what willful blindness is not. And then even more importantly, the Supreme Court ruled out recklessness. And they say, so if the jury were to find that the defendant ignored an unjustified and substantial risk of wrongdoing, that's not enough. And so I think that's going to be, if you can get the instructions to be a lot better than the pattern instructions are now, and I think Global Tech gives you the ammo to do it, you're going to be able to really, hopefully, drive home for jurors all the things that the government could have proven that would still require them to acquit your client, as opposed to before, where the standard was so murky that you would get into these cases and the government would really make arguments, and we had them in the Geisen case, they're also in the Bork case too, where the government would really make arguments that would use language like, well, he should have known. I mean, maybe he didn't actually know, but he sure should have, because look at all the facts that were out there that would have given him knowledge. That's not a willful blindness case anymore under Global Tech, because what the government's missing in all those cases is, well, and look what he did to actually avoid learning of all these things. So I think that there's a lot of good fodder out there for good jury instructions post Global Tech.
Okay.
All right, well, that's where we are, so questions?
You expressed some skepticism about whether even in Jewel there was evidence of active avoidance. Can you kind of describe what that might look like in a case like Jewel?
Yeah, I mean, I think that if they had said, if somebody had a conversation, if there was evidence that there was a conversation in Jewel, that, you know, we'll give you $100, here's the car, here, and let me tell you, you know, what's in what you're going to be driving across in case the feds talk to you and say, look, I don't need to know any more than just, I'm going to get $100, I'm going to drive the car across the border. I think that sort of statement could obviously be the sort of active effort to avoid knowledge. I think that, you know, if it turns out that you know, there was a compartment that was open and you had Jewel point out to the guys, there's this compartment that's open, I don't want to know what's in there, would you go close that for me? That would be some sort of active effort to avoid knowledge. So I think, you know, so I think in Jewel, you're going to probably need some sort of statements that involve active efforts.
One of the things in the Jewel case that's actually mentioned is the fact how conflicting the facts are from the two different perspectives. And it clashes, in my opinion, against what is the inference standard. You know, what you can infer from the evidence, which is the typical instruction you always hear courts doing, versus the active. And you're going to have a clash on those two in a large respect.
Well, I mean, the thing is that in terms of the active avoidance requirement, there were some cases where the lower courts and the Sixth Circuit too would make noises about active avoidance, but they'd never impose it as an actual element. And so what they would usually do is say, this is the scenario in which willful blindness should take place, but then they would look at whether the evidence showed that the client knew or subjectively knew there was a high probability that the fact existed, and they would look at facts that really went to negligence to confirm it. And that's basically what happened in Geisen. I mean, the other thing, though, in cases out of the Sixth Circuit, and there's a pretty well-known Sixth Circuit case on this, was that the Sixth Circuit and other circuits would often avoid even determining whether or not the doctrine of willful blindness had been shown, because they would say, even if we assume that there is no evidence of willful blindness, that there's nothing that will meet this standard, and they did this in Geisen as well, that they did a little discussion before it about saying, well, we think there may be evidence of willful blindness, but we don't need to decide it, because I think this is still in play post-Global Tech, and it's one of the two issues that I think will eventually be up to the Supreme Court. The courts would hold that if there's any evidence sufficient to get to the jury on knowledge, giving a willful blindness instruction, even if there was no evidence to support it, was always harmless. And the way they did it is they said, we'll assume that the jury convicted on an active knowledge theory, because there's this doctrine that said there's this doctrine that says if the jury has two factual theories in front of it, and one has evidence and the other doesn't, jurors are as good at figuring out the facts as judges, and so therefore we'll assume that they convicted on the evidence for which there's factual support. The problem is that in a factual case where one theory is marijuana and the other theory is cocaine, which I think was the facts in front of the Supreme Court, and there was no evidence of marijuana and there was some evidence of cocaine, it's pretty easy to assume that if the jury convicted, they convicted on a cocaine theory. But in an area like willful blindness and knowledge, where it's so hard to separate out, and it's really it's giving two legal theories to the jury, I think there's a strong argument that can be made that doctrine shouldn't be applied. But the Sixth Circuit and most lower courts do, so they often have these cases where they say, there's no willful blindness, or we'll assume there's no evidence that would support a finding of willful blindness, but it doesn't matter because there was at least enough evidence to get to the jury of active knowledge. We had that happen to us in Geisen. Question in back?
I actually have an appeal pending in the Third Circuit where this second element has never been part of a willful blindness instruction, and it's on a concealment money laundering case where I have focused on, the Cuellar intent to conceal aspect of the insufficiency of the evidence, but now I'm thinking that I should really file a 28J letter on this, except that the Supreme Court has said this has always been the standard. This is like this
I mean, I'd definitely file a 28J in a case like that, and I think, you know, was there an objection to the instruction when it was given, to the language in it?
I wasn't trial counsel when there was no objection.
Yeah, I mean, I still think I would file a 28J and say this instruction is clearly deficient under Global Tech, and maybe even, you know, make a plain, I mean, certainly it can be plain error. And so even and it's obviously plain because the Supreme Court said it's always been the law. So you know, I think if you file a 28J, you may want to think about whether or not you address the plain error issue too.
I've thought about that actually, and I lean towards the side of not actively doing it. And let me explain why. It's going to depend on the case. First of all, if you're dealing with a conspiracy case where it requires a specific intent, I think you can distinguish that of why the inferences might not be rising to the level of specific intent. The other example I'd use there are cases like Ratzlaff and Cheek, which give a definition of willful and what is required of willful in certain contexts. Now, those haven't been extended to some of the other contexts. For example, I haven't seen it extended in some of the environmental cases. So I'm concerned about, in some cases where you may have a stronger argument, if you're dealing with a money laundering case where willfulness still existed in the statute and you can contest that you don't meet the willfulness standard, I'm not sure that you should have any type of willful blindness there in the first place. So in that specific example, I'm not sure I'd go in that direction.
Right, I mean,
Yeah, go ahead.
I mean, my one
Next.
thing to add to that, I totally agree with Ellen that I don't think you want to bring willful blindness into the case if it's not already there. And so I'm not sure that I would ask for a willful blindness instruction in these cases. But there'd be nothing stopping you from using the recklessness and negligence language in a knowledge instruction. So if there's an instruction on what knowledge is, certainly knowledge is not recklessness, knowledge is not negligence, just like it's not willful blindness. So I'd probably try and add to the knowledge instruction that negligence. One of the nice things that Dane Ball's article does is it walks through the Fifth Circuit pattern instruction. It shows all the things that we just talked about in terms of the problems with that instruction and leaving out one of the elements and not having, you know, a discussion about recklessness and negligence.
I certainly would try to use it, and some of the cases I'd point out are some of the Sherman Antitrust Act cases, where it's exactly what the court has held in so many of those cases, that we use the civil standard the same as the criminal standard. And I've long argued that those should be distinguished because of the different standard of reasonable doubt in one and not reasonable doubt in the other. But you know something, I'm going to backtrack a little bit on that one right now when it comes to this argument.
Yeah, I think first of all, that should be the effect, is that because this standard was promulgated in a civil case where the Supreme Court was talking about knowledge, certainly it has to apply in other civil cases where the Supreme Court's talking about knowledge. The only reason I think it applies in a criminal case is because the Supreme Court went out of its way to discuss the fact that this was a criminal law doctrine. It's not clear otherwise that it would have applied in criminal cases, although because they made it very clear that's what they're talking about, I think it does. I think the second big impact in investigations that you're talking about, where you have the SEC and where you have DOJ and other agencies involved, is that I think prosecutors now are going to be looking harder in these cases for evidence of active avoidance, and I think they're going to be looking a lot of times in internal investigations, because that's what happened in Global Tech. So Global Tech left out a fact when they conducted this due diligence. They left out the fact that they had copied this deep fryer from a patented product. And I think what the prosecutors are now going to do is that if there is an investigation that's been done, they're going to want to rife through the investigation to see what was disclosed, because if something wasn't disclosed, that's the sort of thing that can give rise to willful blindness. And so I think in the quality of the due diligence investigations post Global Tech might be at risk in some of these big multi-jurisdictional cases.
One thing I would also add to that is look at the burden of proof here too. I think you should emphasize who bears the burden of proof in this examples of the active avoidance, and that this should be placed upon the government, because it is basically, if knowingly is an aspect of the statute, then it's the government's position that they have to prove it. And if they're going with willful blindness, they also have to prove that. And so using the burden of proof type standard and reasonable doubt type arguments on this active avoidance, I think would be very strong also to fortify the arguments that you're making.
Well, I mean, I guess the question in my mind would be, if you have a case where you think the government's looked for active efforts to avoid and they haven't found anything and there's just not any evidence there, and you think that that getting the willful blindness theory in front of the jury at any stage is gonna muck up your knowledge case, and even if ultimately you get a Rule 29 motion granted on a willful blindness theory, that'd be the sort of case that I'd file a motion in limine to just keep this out, because you think that it's not going to do the government any favors to give them the heads up about it. In a case where you think there might be something out there that could get the government to the jury on an active avoidance theory, and if you file the motion in limine, you're going to tip them off, and they're going to probably go look for it and find it. Then I wouldn't file a motion in limine. I would try and wait, hope the government doesn't find it, get to the Rule 29 stage and try and, I mean, the problem is that it's hard to knock this out at the Rule 29 stage, because it's usually not going to be an extra count unless their only theory is one of willful blindness. I mean, they're going to usually have a knowledge theory and a willful blindness theory, and you're going to have to knock them both out. But if you can do it at the Rule 29 stage, and you're worried that if, filing early is going to tip them off to something that they haven't found yet but might, then I'd wait. I mean, I think you're going to have to, it's all going to depend on the case, but if you've got a case where you think you can knock out this theory and that it's going to be really, really harmful if it ever gets in front of the jury, even if it doesn't even result in an instruction, you'd want to knock it out. Although you might have a case where the government commits to showing actual knowledge over and over and over again, and you want to lock them into that commitment because they're just not thinking they're going to need to show willful blindness, then their case falls apart when they put it on. I mean, that's really what happened in Geisen, was that the government never thought for a moment that they were going to turn that into a willful blindness case. It didn't make any sense, in part because there was no motive to actually willfully blind yourself to any of this information that was going in the NRC submission, which is actually an issue that I think will survive Global Tech. That's one that the circuits are split on, whether the government needs to prove a motive to, that your motive in blinding yourself was to avoid guilty knowledge. And so in a case like that, where the government was never thinking about it until they got through the evidence and decided, we really don't have a lot, maybe, but this guy just got up on the stand and said he really should have known better. Maybe if we can get a willful blindness instruction, it'll muck things up enough that they'll convict him on a negligence theory. And they were able to do that in the Geisen case. And I think that in some cases like that, where they've locked themselves in early, and you're thinking, I don't want this to play out the same way, you might want to try and lock them in. They might have even agreed to it in a case like that before trial, because I don't think anybody was really thinking that this was going to turn into a willful blindness case. Even the judge, when he was hearing argument on the willful blindness instruction, really made a lot of noises about how it made absolutely no sense in a case like that. And so I think that that's the sort of case where everybody might agree before the trial starts that willful blindness, just isn't part of the case, whereas once you get through the evidence, the government's really trying to find anything it can to get in front of the jury so that they can hang their hat on it.
I do. I think, for one, it would really be nice if some criminal defense lawyers out there took Justice Kennedy's language and tried to frame an argument based upon that. A second issue I could see is where the government argues that they should be entitled to a willful blindness instruction and that they have this active, participation in some way, and it really isn't there to some extent, and then they argue later on appeal that this is harmless error because there's so much evidence there. And I think you may be able to play off these two things, one against the other, on the appellate issue. If it really was that there's so much evidence of the activeness, then you don't need willful blindness. It's kind of bizarre in a way. If the person actually knew in some way, why do you need the willful blindness in the first place? So if you start thinking that through, I think you could develop some issues in that regard, and I anticipate there will be some. I also think that all the instructions in all the different circuits are going to be contested, and I think you're absolutely right that we need to collect all this information, because if we've got some good, strong ones, to let other circuits know about them is going to be very important. And sometimes they're just decided in the district court and don't get reported. And so to keep that information through NACDL or my blog or wherever, so that other people can hear about it, I think is very important.
Yeah, I mean, I agree. I think there's basically three issues that are likely to go up, in the next 5 years or so. The first is going to be, I think there's going to be basically chaos on these instructions, because the pattern instructions really don't survive Global Tech, but, I think certainly Global Tech doesn't say anything like that in it, and so I think there's going to be a lot of courts that are going to still give their pattern instructions post-Global Tech because they're the pattern instructions, so they must be right. And so I think you're going to see a lot of litigation on that, and you'll probably get some circuit splits developing pretty quickly on whether or not the pattern instructions survive Global Tech. I think the harmless error issue is still a mess. And I think to some extent Global Tech, because it really goes through and analyzes whether or not there was sufficient evidence of willful blindness, and that's what the case turns on, gives a little more ammo to the idea that there ought to be a traditional harmless error analysis in willful blindness cases. And I think that's an issue on which the circuits were already split. I think it'll probably develop even more strongly post Global Tech, and I think eventually the Supreme Court will take that. I mean, one of the things that's interesting about Global Tech is the Supreme Court talked about how the law was settled, and it talked about in the circuits, but what it didn't come out and say outright is that it's been asked to take willful blindness cases all the time. It gets a lot of cert petitions on this issue. It's never taken one in a criminal case. The Supreme Court's never actually sat down with briefing and spoken to the doctrine of willful blindness. I think they will on this harmless error issue. And then the third issue is this motive issue. The Ninth Circuit split 6-5 on this motive issue about 3 years ago now. There was a really good dissent from I think one of the judges up in Alaska, who's not kind of one of the usual suspects you'd expect for a Ninth Circuit dissent, and so and made a really good argument for why this motive requirement was needed. And I think there's a little support for that out of the Global Tech case too, because the Supreme Court talks about how this doctrine ought to be very limited, and I think that's the whole point of the motive requirement, is giving jurors a fact to focus on. Is this the kind of case that somebody would be wanting to deny knowledge, like Juul was? I mean, Juul's the classic case where if it's contraband in your car, you don't want to know about it, because if you know about it, it'll make it easier to prosecute you. That's the sort of motive that some courts have required. In a lot of white-collar cases, there's really, at least in many instances, not in Global Tech and certainly not in Bork, but in a case like Geisen, you can't even figure out a reason why this guy wouldn't have wanted to know about the fact that was false in the submission to the NRC. And in fact, there was evidence in the case that when he found out facts that were wrong before, he'd go back to the NRC and correct them. So I think those are the three issues that are probably going on.
I think our time is up, so thank you very much. We're going to be talking about willful blindness, and when we first were put on this program, we were putting together materials that you were given, and the materials are, quite frankly, a little bit outdated now as a result of a Supreme Court decision that nobody anticipated. And we're going to spend a lot of time talking about that. There's a handout. If you did not get the handout, please be sure to pick up a copy of the handout, because it gives you the link to the new Supreme Court case and gives you some excerpts from it. And we also have a PowerPoint that, of course, we can provide.
And I just wanted to say, I mean, this panel this morning is the good news, bad news panel. I mean, the good news is that the Supreme Court has finally told us what the willful blindness doctrine means. The bad news is they did it in a patent case without any input from the criminal defense bar, and so there's still a lot of loose edges, but the materials are, in fact, now outdated because they were all written before the Global Tech case came down in the last month. Now, there's still some things you can use out of them, but they certainly didn't anticipate the Supreme Court would rewrite willful blindness in a patent case.
And the good news is, there's a lot of great things in that global case. Let me just reference one article that just came out. It's in the Criminal Law Reporter. It's written by Dane Ball. And it's a wonderful article on the Global Tech case on willful blindness, and Dane has been kind enough to get me permission from the Criminal Law Reporter to post it on my White Collar Crime blog. It's not up there right now, but it will be up there within the next 24 hours, depending upon airplane flights.
I also wanted to give a shout out to that article. I think a lot of the things that we'll talk about today, particularly with respect to jury instructions, are laid out very nicely in that article. So if you have a willful blindness case, you really should use that article as a resource for your jury instructions.
We're going to talk about three things today, and why three? Well, because I was schooled by Terry McCarthy. And Terry McCarthy told me, whenever you're doing a presentation, you always do things in threes. And if you have four, make them three. If you have two, make them three. And so we're going to talk about three things. The first thing that we're going to talk about is, what exactly is willful blindness? So I'm the academic. I'll probably go through a good portion of that. Then how to avoid an instruction on willful blindness gets more into the practical. Tim's going to take over there. And then if you can't avoid it, what's the best possible instruction that you can use? So those are basically the three aspects of what we're going to talk about today. So what exactly is this willful blindness? It's been called many things: the ostrich, the deliberate avoidance, deliberate ignorance, and those are the different terms that you'll hear used. I should tell you that Judge Posner out of the Seventh Circuit is rather upset that it is being called the ostrich instruction. He actually made a point in Conrad Black's case to do a whole section about the ostrich instruction, and then he noted in the decision that this is really a misnomer. He said the first is whether an ostrich instruction should have been given. The reference, of course, is to the legend that ostriches, when frightened, bury their head in the sand. It is pure legend and a canard on a very distinguished bird, and he cites to the Zoological Society of San Diego. I'm glad he's visiting those sites. Which he quotes, "When an ostrich senses danger and it cannot run away, it flops to the ground and remains still with its head and neck flat on the ground in front of it. Because the head and neck are lightly colored, they blend in with the color of the soil. From a distance, it just looks like the ostrich has buried its head in the sand because only the body is visible." He then goes on to say, "It is too late, however, to correct this injustice to the ostrich."
One of the nice things about Global Tech, I think, though, is that it might give us a chance to maybe redeem the reputation of the ostrich, because I do think that, and we'll talk about it more later, the Global Tech case really changes the paradigm in a way that I think the term really ought to be active avoidance, and it's not in any of the earlier terms, but the action is really going to be important, as we'll talk about later.
Which you might want to use the ostrich who is laying his head and not burying his head in the sand. The willful blindness chronology comes from the English law. It dates back quite a ways. 1882 was its first reference in United States law. In 1962, the American Law Institute incorporated the doctrine into our basic sort of structure of criminal law. It defined knowledge as knowledge of the existence of a particular fact. It includes when a person is aware of a high probability of the fact's existence unless he actually believes that it does not exist. One of the interesting things about the American Law Institute's 1962 reference is that Global Tech goes back to the American Law Institute reference and uses it to build up something that we think is very helpful for criminal defense in that respect. May 31st, 2011 is the Supreme Court Global Tech's opinion where they stated, every court of appeals, with the exception of the District of Columbia, has fully embraced willful blindness, applying the doctrine to a wide range of criminal statutes. What is the classic willful blindness? The classic willful blindness comes in the United States versus Jewell case. You've got the situation where the defendant is going across the border, he's carrying 110 pounds of marijuana, it's concealed in a secret